Shares for €1. English court upholds the integrity of BVI corporate structures against asset stripping attempts. In a recent decision of the English Commercial Court, GLAS SAS, London branch, as trustee of €250 million in tradable bonds, succeeded in claims against a BVI-incorporated company and related parties for the misappropriation of shares worth approximately €85 million. The judgment is a comprehensive illustration of how English courts deploy Section 423 of the Insolvency Act 1986 extraterritorially, and of the tort of unlawful means conspiracy, where assets are stripped through offshore vehicles. Background. GLAS was the trustee of English law bonds with a principal value of €250 million issued by European Topsoho, ETS, a Luxembourg company and indirect subsidiary of the Shandong Ruyi Group, a major Chinese industrial conglomerate. ETS owned approximately 53% of the shares in SMCP, a French fashion company. Some shares were pledged to GLAS as security. The remainder, the unpledged shares, had a value of approximately €85 million in October 2021. GLAS's case was that Ms. Chu, a senior Ruyi Group executive and A manager of ETS, procured the transfer of the unpledged shares to Dynamic Treasure Group Limited, a BVI company she personally controlled, under a purported share sale agreement for €1. Dynamic then converted the shares to bearer form and transferred them to its account with JP Morgan in Singapore. ETS was subsequently declared bankrupt in Luxembourg. Its court-appointed bankruptcy administrator investigated the transaction independently and reached similar conclusions to GLAS. The transfer was not a genuine commercial arrangement. The defendants were debarred from defending the claims by reason of persistent non-compliance with court orders, including failures of disclosure across proceedings in England and Singapore. Although debarred, GLAS accepted it had to prove its case on the balance of probabilities. The decision. Governing law. The court held that English law governed both the Section 423 claim, as the law of the forum, and the economic torts under Article 4 of Rome II. The damage occurred in England because GLAS was entitled to call for payment in England under the trust deed, and the bonds and trust deed were governed by English law. The court dismissed Shinbo's contention that PRC law applied. The 2018 agreement. The court concluded that a purported 2018 pledge agreement, under which Shinbo claimed security over all SMCP shares, was not genuine and had been created after the event and backdated. Among the numerous difficulties, no contemporaneous documents existed, the B managers had no knowledge of it, ETS's own managers certified in 2021 that no security existed over the shares other than the bond security, and the arrangement was commercially implausible, given the shares were worth €960 million at the purported date versus Shandong Ruyi's supposed debt of €177 million. The SSA and the disposal. The purported share sale agreement was held to be invalid. There was evidence that Grandel, Dynamic's corporate director, did not sign the SSA. The transfer lacked the required consent of Sino Power under ETS's articles. No B manager co-signed as required, and the €1 consideration was plainly a transaction at a substantial undervalue. The Beihai Award. A Chinese arbitration award relied upon by the defendants was dismissed as collusive. The arbitral process took place between parties under common control who agreed all substantial points without argument. Shinbo's attempts to enforce it had been dismissed in Singapore, and it had abandoned English recognition proceedings. Section 423 Relief. The court granted relief under Section 423, holding that the disposal was a transaction at an undervalue entered into for the purpose of putting assets beyond the reach of GLAS and the bondholders. The court confirmed that Section 423 contains no territorial limit and exercised its discretion given the substantial connection with England. The bonds, trust deed, and enforcement mechanisms were all English law instruments. Unlawful means conspiracy. The court found Dynamic, Miss Chu, and Shinbo liable for conspiracy to use unlawful means, including breaches of Luxembourg criminal company law provisions, directors' duties, and breaches of the trust deed. The intention to injure GLAS was established because the conspiracy would cause ETS not to make the largest and most timely payment it could under the bonds, inducing breach of contract. The defendants were also held liable for procuring ETS's breach of the trust deed by effecting the disposal. Damages, quantum to be assessed at a subsequent hearing, and declaratory relief were granted across all claims. Practical takeaways. This decision is significant for practitioners in offshore jurisdictions for several reasons. Integrity of BVI corporate structures. The case illustrates how the courts will uphold the integrity of BVI corporate structures against asset stripping attempts, ensuring the attractiveness of the BVI as a jurisdiction in which to invest. Dynamic was incorporated in the BVI. Its shares were subsequently transferred to another Ruyi-connected entity, and it was through Dynamic that the misappropriated shares were held in Singapore. The English court had no difficulty looking through this structure. The BVI has similar, but not identical legislation to Section 423, upholding the integrity of BVI corporate structures. Extraterritorial reach of Section 423. The judgment confirms that Section 423 of the Insolvency Act is not territorially limited. Where English law instruments underpin the relevant obligations and enforcement mechanisms, the English courts will exercise their discretion to grant relief even against foreign entities and in respect of foreign transactions. This is directly relevant to disputes involving BVI and Cayman entities where the underlying debt or security arrangement is governed by English law. Debarring orders and adverse inferences. The defendants' persistent failures to comply with court orders, including disclosure failures across multiple jurisdictions, led to debarring orders. The court drew adverse inferences from the defendants' failure to disclose documents and adduce evidence. This reinforces the importance of compliance with procedural orders in multi-jurisdictional disputes. Collusive arbitration awards. The court's willingness to look behind a foreign arbitral award that was obtained collusively between related parties is of particular interest. Practitioners should be alert to parties attempting to manufacture arbitral support for fraudulent arrangements. Cross-border coordination. GLAS pursued proceedings in France, England, the BVI, and Singapore simultaneously. The BVI and Singapore proceedings were stayed in favour of the English proceedings, demonstrating the practical reality of multi-jurisdictional coordination in complex fraud cases with an offshore nexus. While Harneys does not advise on the law of England and Wales, this judgment is directly relevant to BVI practitioners. It underscores that courts will uphold the integrity of BVI corporate structures against asset stripping attempts. Similar, but not identical, legislation exists in the BVI, further reinforcing the BVI as a jurisdiction where corporate assets are protected through the operation of law.